Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of what is willful blindness. Colorful term, but what does it mean when you're talking about FBAR penalties? I apologize for those of you that listen to the reckless disregard that we also prepared. They're companion pieces, but for those of you just listening for this, I'm going to go through and kind of go through the basics again. You could just fast forward it if you don't want to hear me keep talking about the same basics. FBAR, foreign bank and financial account reporting, used by U.S. persons to report foreign accounts, bank accounts and financial accounts. It's for U.S. persons, so that's U.S. citizen, legal permanent resident, foreign national who meets the substantial presence test. That's just individuals, entities, trusts, and estates may also have to file. So what happens is, if you don't file it, the IRS is going to ding you, and they can ding you heavily, especially if it's willful. Most people get dinged, penalized because they didn't file it or they filed it late. If it's inaccurate, that's less penalties. Normally, you'd probably get a soft letter and an opportunity to fix it. If you filed it timely, identified the accounts, you could probably dance around that. Penalties can be civil or criminal in nature. Criminal is pretty rare. It normally accompanies something like structuring, smurfing, tax evasion, money laundering, things like that. The more common are civil, and then you've got willful and non-willful. Non-willful is more common, but willful is picking up its pace. IRS has been hitting people with more of those willful penalties, and it may get even worse because of some recent cases that essentially limited the IRS to one penalty per form, not one penalty per violation per form. Okay. Willful penalties are generally 50% maximum value of the account or $100,000, which is adjusted for inflation. Whatever's higher, which makes the $100,000 basically the floor. Normally, the agents are going to issue the highest. The 50% max value, that's the highest that they can hit you with. So normally what would happen is they hit you with the max, then you have an opportunity to possibly mitigate that. Examiners and agents may not seem like it, but they absolutely have discretion, especially through their supervisors, to reduce the penalty if you can show some mitigating factors. What's willful blindness, right? It's willful blindness, right? So basically the idea is you're intending to be blind. See, when you're dealing with willfulness, there's no bright line test, bright line rule. It's not like you have 4 factors, you go through them, and if you meet those factors, you're willful. You go through the Internal Revenue Manual, and there's various elements and factors to consider, but they're not absolute. Instead, you use what's called a totality of the circumstance. Look at all the facts and scenarios. Look at your facts and scenarios, put it together, and see where you might fall. You know, you might have a heightened sense of non-willfulness, let's call it, but you're still non-willful, right? The problem is there's lower forms of willfulness, one of them willful blindness. If you get dinged or held to be liable for willful blindness, well, guess what? You're going to get the same penalties you would have gotten if you were absolutely intentional. It's stupid, but it's the way they do it, okay? So willful blindness, no actual knowledge. Let's go through the basics. You go through law school 101, right? You're walking around somewhere and someone comes up to you and goes, hey, do you want to drive my car back? It's I need you to drive 50 miles. I'm going to pay you $1 million. You go, well, that's odd. Strange. But you go, okay, fine. So get $1 million. You get in the car, you drive, you get pulled over. They find 200 pounds of uncut coke in the car. And you go, but I didn't know. And they're like, well, dude, someone just paid you $1 million to drive the car 50 miles. You should have at least thought into it and thought something may be amiss. That is the idea of willful blindness. You're intentionally keeping yourself blind from the information that you should know. Had you known it, you probably wouldn't commit the act. Okay. If you think you may have violated the FBAR penalties and you want to get into compliance, there's various amnesty programs that are available to assist you. You may see the term offshore voluntary disclosure and see that they ended OVDP. Doesn't mean they got rid of voluntary disclosure. OVDP was an offshoot of the program used specifically for offshore. They closed out in September 2018. A few months later, they expanded the traditional voluntary disclosure, which has been on the books forever. That's used for both offshore and domestic. If you're non-willful, you have many other options available to you. You got the streamlined programs, you've got streamlined domestic, streamlined offshore, you've got delinquency procedures, delinquency FBAR procedures, and reasonable cause. We have lots of free information available on our websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.